You're Free to Go is sponsored by Milburn Men's Clothing, where top athletes shop for sharp, tailored style. And whether Mark and I are in the studio or the courtroom, Milburn dresses us for success. Mention YFTG and get 10% off at Milburn Men's Clothing, which has been providing the finest in men's clothing and suits since 1946. Call 651-645-2922 or visit www.milburn.com. Hello, everybody. We're excited to be back. Welcome to our next episode of our podcast, You're Free to Go. This is the podcast where you hear about real cases from real lawyers, actually the cases that we've handled throughout our career, which has over 80 years of experience between the two of us handling criminal law cases. So again, thank you for tuning in. We're happy to have you. And today, Mark and I are going to discuss something that comes up every time we represent someone and every time we talk to someone about what we do for a living. And Mark, I'm going to put it at you to start this off. How do you handle it when every time people say, do you know if your client is guilty? Did they tell you they're guilty? And if they do tell you they're guilty, how do you defend them? Can you defend them morally, ethically? Like, what do you do now you know your client is guilty? They always ask us, did your client tell you they did it?
Well, you're absolutely right. That's probably the question I get the most from people who are fascinated about criminal law. And, there are a lot of different situations, but primarily it comes down to whether or not my client is willing to tell me the truth. And, over the years, my stock in trade in representing different people in different types of crimes have broken down into kind of three areas. Mob guys that I've represented, drug dealers, drug lords that I've represented, and white-collar criminals.
White-collar being business crimes.
Business-related, anything from securities fraud, Ponzi schemes, we're talking public corruption sometimes, tax cases, right. Those sorts of things. And what's interesting is, and you wouldn't really think about this being the case at first, is my mob guys and my drug dealers generally were truthful with me.
Right.
It was my white-collar criminal cases, my clients in those cases who usually were BSing me. Because in truth, the first person they would BS is themselves. So it was like peeling layers of onion, trying to get down to what the truth is. And it comes down to trust, first of all. If the client trusts you, and they have to trust you. Because I've always said to clients, if you don't tell me where the potholes are, where the sinkholes are, where the problems are, how can I probably avoid them? And how can I best represent you if I don't know what's coming at you?
I have that issue come up very often with clients. I guess every time we have a client, you may most likely have never met them before. So now they're putting their freedom in your hands, their life, so to speak, and they have to trust you, but at first they may not. And so it takes a while to build that trust. And I'll have a little conversation with the client where I'll say, it's really important that you are honest and open with me because I can only help you if I know all the information. And I use this silly example that every client relates to. And I tell them about a client who told me they had no criminal history. And then I went to the prosecutor and I was arguing and advocating on behalf of my client, trying to get a really good deal. And at the very end, my last, line was going to be, to get it across the finish line was, and by the way, they have no criminal history. Prosecutor looked at me and said, sure they do. Your client's lying to you. 30 years ago, they got arrested for having a sword at the palace.
Oh, that's like one I had where my client told me he had no criminal history. And the prosecutor, the U.S. attorney, pulls out a Sports Illustrated from many years ago. The cover page was about a betting scandal at a school.
I remember that one at Tulane.
Right, exactly that one. And my client was behind it.
Yes.
And he was arrested and charged and convicted.
Exactly right. Yep. I remember that because I actually went to Tulane and I was there during that whole scandal. So I know who you're talking about and all about that case. The funny thing in my case, I, I talked to my client about it. He said, when I was 14 years old, I went on a teen tour to London, and we went through a bazaar, and I bought a plastic sword. And then we went by the palace, and someone stopped me, took the plastic sword from me, and gave me a little piece of paper. I got home, gave it to my parents. They sent in $20. That was the end of it. I thought it was a little, I didn't know what it was. Turns out the government knows everything. So, of course, the prosecutor started laughing when I figured it all out. But my point to my client was, when I represent something to the prosecutor based on what you tell me, if it's not accurate, they're not going to think I'm lying to them because they know our reputation. They know we speak the truth. They're going to think my client is lying to me, and that's only going to sabotage your case.
It's a credibility issue. So, my question to you, because I know people ask me this all the time, is when your client tells you the truth, and let's assume that truth is, yeah, I was involved in that crime, does it affect your ability to represent them?
So if my client tells me the truth and they actually admit that they committed the crime, does it affect my ability to represent them? The answer is no, it does not. I still have the obligation ethically under the law, under the rules of the bar and so forth, to do the best I can to represent them. And I try to separate myself from the crime as far as taking it personal and just stay in the role of a criminal defense attorney fighting for that client and making sure that the government did their job properly. If the government dotted their I's and crossed their T's, then the client is very likely going to be convicted. And there's a different approach we have to take where I have to look at what would be the fair and just outcome for my client, even if they admitted, yes, I did this. And it goes down to the fact that just because someone committed a crime doesn't mean they need to be locked up and put in prison. There are other ways to for someone to understand the consequence of what they did. And so I don't have any difference in how I approach a case or how I feel about a client when I know they committed the crime and they've admitted to it. Maybe part of that is because we've been doing this so long.
Right. And I think a lot of it has to do with the fact that the way our system works, which is that the government has to prove, the state has to prove the crime. The burden is on them. And as a result, the defendant is presumed innocent. And a lot of people don't really understand that application. And I know when I pick juries, one of the questions I ask people is, at this moment in time, if you had to render a verdict, what would your verdict be? And the average person, would say, well, I don't know enough about the case to give a verdict. And that's when I would correct them and say, well, I understand, and that makes sense. But you see, under our law, because there is a presumption of innocence and the burden of proof is on the state or the government, what happens is right now, if you had to render a verdict without hearing anything, the verdict would be not guilty because he is presumed innocent.
Right. And that's a point we always have to hammer home because there's that theory that people have that where there's smoke, there's fire.
Right.
So just by the fact that they're sitting in the defendant's seat and they've been arrested, then there's something shady going on, so they must be guilty. And also a lot of times, as we know, when someone gets arrested, it's plastered all over the news, and the presumption of innocence goes out the window. People, they're made out to be guilty from the get-go in the media a lot of times, which is so unfair. It's unconstitutional because we do have it's a sacrosanct, constitutional right that you are innocent until proven guilty.
Right.
And it's not just proven a little bit guilty, it's proven beyond a reasonable doubt, which is the highest burden in the entire court system.
Right. And, it's interesting because we're always asked, well, what happens if you think your client's guilty, their story is ridiculous, and yet they're absolutely insisting on this fanciful explanation that probably belongs in Disney World. What do you do in a situation?
No, I want you to talk about that case where you did the polygraph on your client.
It's interesting. I had a client once who absolutely had the most ridiculous story about how he got involved in this situation. And I listened to it, and I almost broke out in laughter. And I said to myself, if I put him in front of a jury, it's going to be a comic act.
Right. No one's going to believe it.
No one's going to believe him. And they're going to laugh at him. And he's going to be convicted in a millisecond. So I said to him, you know what? If you're absolutely convinced, would you be willing to take a polygraph? Now, we know the polygraphs are not admissible in evidence,
Right.
but nevertheless, they can be a valuable tool sometimes in ferreting out whether somebody is telling the truth or not, or at least used as a mechanism to get the client to see what's going on.
You know, when I bring that up with clients and I explain to them I'd like them to take a polygraph, but they are not admissible, they always say, well, then why am I taking it? And I always tell them that every open investigation that is not solved, law enforcement always asks for a polygraph. And the reason they ask for them is even though they're not 100% scientifically reliable, so that they're not admissible in court because of that, they are very reliable. They're just not 100%. And so officers use that every day in this country as an investigative tool to further their investigation. So why shouldn't we, on our end, privately with our client, use it as an
Well, if the
investigative
client's
tool?
insisting on their story and it's unbelievable, and it's going to be a problem selling it, and you know it's going to be a problem, then a polygraph might be a useful tool. And in that scenario, what happened in this one case, this crazy case, I said, okay, we'll take a polygraph. And he was agreeable. He was insistent that he wants to take a polygraph because he was saying, I'm absolutely telling the truth. So we went to a very respected polygraph expert down in Miami, George Slattery, since passed away.
Great guy.
And I remember Slattery coming out of the room, but my client's still in the room, and Slattery says, oh boy. It's lucky he told the truth about his name, because that's about the only thing
Yeah.
he told the truth on. And so when the client came out and he thought, oh wow, we're great, right? I said, no, you failed miserably. So he said, oh, this guy doesn't know what he's doing. So then I took him to another polygraph expert up here in Broward County, and same thing happened. So he was still insistent that the polygraph guys, the experts, didn't know what they were doing. So I said, all right, find your own expert. And he found the guy, and I suspected he may have paid off the guy or whatever.
Right.
You know, I didn't know what was going on. And I'd never heard of this guy that he brought me to, and it looked like he was in a tattoo parlor.
But he selected him, right?
Right.
Yeah.
So I brought him, and then my client comes out, and he's angry. And I said, what's the matter? He said, I failed. I said, well, you know what, buddy? Baseball. 3 strikes, you're out.
You're out. He was
I
out.
said, this isn't going to sell. And about a week or 2 later, he broke down.
Oh,
And he
good.
finally admitted things that he hadn't told me about. And at the end of the day, it was helpful in fashioning a way to get him out of this situation.
Well, yeah, the truth is, unless they tell us everything, we don't know what's going to come at us from the government, because the government knows everything. They're on top of everything. They're looking everywhere. And if our client is giving us half-truths or only telling us 80% of what really went down, we're going to be caught off guard, and then we're not going to be able to represent our client as well as if they tell us everything. So
Right.
it's so
So then the
important.
problem comes up. What happens if your client tells you that they were actually involved in the crime in some fashion? And then we're in trial, and the client insists on taking the stand, which is his or her constitutional right. You have to allow them to do that. But the client tells you that they're going to say something completely different. They're going to lie on the witness stand. How do you handle that?
Right. Well, lawyers under the bar rules and ethics are not allowed to support perjury. So if we know a client is going to lie under oath in court, we have an obligation not to allow that to happen. It's the reason that I have and I think you do too, an ethics expert on speed dial. Because in our practice, in every legal practice, issues of ethics come up all the time, and it's really good to be able to rely on an expert to get run the fact scenario by them and get the direct advice. The other idea is thankfully the Florida bar and other bars around the country have hotlines, ethic hotlines. You call them as well. But if you're in the middle of a trial and you don't have
that ability,
right? So it's interesting. In my understanding, and I've been in this situation, if I think my client's going to lie and they're insisting on taking the stand, which, as you said, is their constitutional right, I put them on the stand and I ask them one very open-ended question, tell us what happened. And then they just go into a narrative answer and explanation from their own words. That way, we're not actually soliciting questions and getting answers that we know are lies. We just put an open-ended question. Of course, the opposing counsel, which is the prosecutor, is going to object on certain grounds, and then we have to go before the judge. But you know what happens then. The judge is now aware that we obviously think our client's lying, and that's why we're not asking questions to our client, and we're letting
Yeah,
them.
it's a conundrum because there basically are two opposing issues here. One is our commitment to represent our client to the best of our ability and our commitment to get that client found not guilty of the crime. And the other is, as an officer of the court, we can't suborn perjury if we know it's going to be perjurious testimony. So how do we deal with that? And the only way, and it's been a conundrum for lawyers for forever. And, various, bar opinions exist on this. The bottom line is, most of the time we're advised exactly what you say that you did, which is you don't solicit the testimony. You allow the client to testify. But ultimately, like you say, the judge now knows exactly what's going on. So if your client's convicted, it's to the moon, Alice.
Right. Yeah,
they're going.
They are going.
They're going away big
Yep,
time.
Yep.
So,
The other thing to do if your client is maybe not telling us the truth, and we try the polygraph, or they insist on the polygraph, and we're not getting the truth, and you said this client after 3 polygraphs finally came clean with you. The other thing is these focus group or mock trial where clients giving you this explanation that makes we know it's no jury's going to buy it. It makes absolutely no sense. Like you said earlier, they're going to laugh at it. So we say, okay, let's do a mock jury, a focus group, and they come back and they say guilty. We present the argument that that our client wants us to present, guilty. We do a second one, guilty, and then hopefully, I've done that in cases, and I finally, after the third or fourth or fifth mock jury that comes back guilty, then they usually come clean with us.
Yeah, and that's usually in those cases that I term are like weekend at Bernie's. You're walking the corpse around the room, but at the end of the day, they're dead. And I've said to clients, look, you want to go to trial, I will fight like the Dickens for you, but you have to understand, at the end of the day, what's probably going to happen is you're going to be convicted. So if you want to take that shot, I'm with you, because frankly, I love trying cases.
Right.
It's a wonderful time. But I get to walk out of the courtroom.
We sure do.
You know, and I want to make sure my client is able to walk out of that courtroom too.
Right.
So, but I have another question for you. What happens if your client insists on a particular story of innocence and you're just not able to find any evidence out there to support that? Have you encountered that?
Yeah, no, yes, absolutely. It's so interesting because you want to believe your client, and you develop a relationship with them, and we talked about earlier the trust that definitely develops over time. So now you feel like you've developed a relationship where they trust you and they're open to you and they're telling you something and they're swearing it's true, but there's literally no evidence to support it. I've had that come up. Following is a colleague's case presented in first person. I had someone charged in a murder case. He was a middle-aged professional gentleman with no criminal history whatsoever. He was a single guy. He had someone over at his house one evening. They were on a date at his home, and there was a banging at his door. Bang, 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 bang. And he's a guy who carries a firearm, and he's trained with it. He's very competent and proficient in his firearm and safety and so forth. He goes to the door and he's not going to open it, but then the door starts to the doorknob is basically moving. It's going to open. So he pulls his gun, pushes the door open, and sees a huge body, and he shoots and kills what turns out to be a 16-year-old boy.
Oh, boy.
It was actually his birthday. And believe it or not, for his birthday, he and a buddy were running around doing what I've heard of, and they called in this case, ding dong dash.
What is ding dong dash?
They bang on the door and then they run. And they just make people open the door.
That's a prank that a kid would do, right?
It's a silly, silly prank. And it was so sad that on his birthday at 16 years old, this is what he wanted to do. And he wound up dead. And so the client kept insisting every time we spoke that door was opening up. It was the handle on the door was turning and it was opening. And there was no evidence to support it. We spoke to, obviously, the one victim was deceased, but the young boy that he was with, we spoke to him in deposition. We spoke to him informally. The police spoke to him. The prosecutor spoke to him. We said, no, he wasn't touching the door. He wasn't touching the door. And the reconstruction of the actual crime scene showed that he was about 10 feet away from the front door, and his arms weren't long enough to reach the door from 10 feet away.
So there was forensic evidence that absolutely debunked your client's story.
Yeah, and it made it so tough for me because I wanted to believe his client, never been in trouble in his life. But then again, you're thinking, well, he shot someone, it's probably all a blur. He's in PTSD from this horrific event, right? So we actually have to go to trial because the prosecutor was asking for some substantial jail. I think their offer was like 25 years in prison.
Wow.
So we're at trial. The jury is about to come in the room, and I turn to the prosecutor and I say, will you just let me talk to that one boy, that witness, one more time?
And that was the witness who denied that the fellow who got shot ever pulled on the door,
correct.
right?
Yeah, so he said, sure, go in the hallway. We're waiting for the jury to come up. We have a few minutes. Go talk with them. So I explained to him how serious this was and that our client was insistent that the door was being opened. And finally, after 2 years of litigation, this young boy came clean, and he said, well, my friend had a string that was attached to the doorknob, and he was yanking on it and pulling on it and pulling on it.
So the kid who was shot actually was pulling the door.
Exactly. He was
Wow,
pulling the
with a
door.
string.
My client was telling the truth the whole time.
Wow.
And this other boy, after the shooting, grabbed the string, rolled it up in a wad, and threw it in the bushes.
Which is why the police never found it.
They never found it. Yeah.
Wow.
So it does happen where your client is telling you the truth, but there's no evidence to support it. So, you trying to figure out how am I going to proceed with this case, and you start thinking your client's lying. It turns out that they're telling the truth.
Wow, have you ever encountered that again?
There was one other case. It's kind of a funny case, actually. It was all in the news. There was a group that was going around the country, and they were breaking into very, very high-end jewelry stores. And they hit Las Vegas, they hit New York, they hit LA. Well, they came to Palm Beach, and they hit Worth Avenue, which is one of the most expensive shopping areas in the country.
Sure.
So they had this really interesting scheme. As a lot of people know, the jewelry in jewelry stores goes into the safe at night.
Right.
And during the daytime, it goes back out in the shelves and in the windows.
Right.
They do that for insurance purposes. Sure. Well, this group would go in the middle of the night, pull up to the store and go to the windows. They'd take out the caulking on all the windows. So around the glass window is caulking. They'd pull out the caulking and they'd drive away. They come back during the daytime when all the jewelry was in the windows, put suction cups on the windows, pull the glass out, grab the jewelry, and take off. So that was this group. It was 3 guys and this one young girl. And so they did that in Palm Beach, and then they weren't local, they were heading to the airport in Fort Lauderdale. They got all this great jewelry, and it's about an hour south between the Palm Beach and the Fort Lauderdale airport. Well, in between those locations is Boca Raton, a very, ritzy community. And there was a very expensive jewelry store right off the highway. So they said, let's do a quick grab there. We're going to do an old-fashioned, go in, ask to look at a watch, put it on your wrist, and run out the door.
Huh.
So, yeah, big mistake. So the young girl did that on behalf of the 3 guys. They said, you go in, say you're getting it for your boyfriend, whatever. She did that. She put a beautiful Rolex on her wrist and ran out the store, hopped in the car. What they didn't know was that between that store and back on the highway was a police department. So they're pulling out maybe a mile away from the highway. The police pull them over. They get all the jewelry. It's all in the car. And my client, and then the police, the 3 guys, by the way, they take off. They get arrested, they bond out, they disappear. They still haven't been found 10 years later.
Wow.
The girl didn't disappear. She bonded out and she hired me. And the prosecutor said, Guy, where's the one Rolex watch? We got all the jewelry from Worth Avenue. We got all of it. But she still has the Rolex watch. She's never been in trouble before. We'll give her a break if she helps us out on this case. Just tell us where the Rolex watch is. Turn it over. So I asked her, and she says, I don't have it. I left it in the car.
Where?
In the car. Well, at first, she's like, it's in the car. So I call the prosecutor. She sends someone. It was a Hertz rental car. It was 2 years later, I think.
Oh, so it was all over the country.
It had been rented 1,000 times by then.
Oh, my God.
They find it in Texas. They look in the car. There's no Rolex. So I call my client. The prosecutor tells me, I call my client. She insists a second time, Guy, it is in the car. I'm not lying to you. Well, make a long story short, the third time they still don't find it. I tell her, okay, they're going to prosecute you. You're going to prison. If you can give them Rolex watch, they're willing to let you go off on this. So she's like, Guy, all I can tell you is when the police pulled up, I threw it in the glove compartment. So the Hertz rental people, they go, they look in the glove compartment, they don't find it, they call back. I think she's still lying to me. She goes, I'm telling you it's in the glove compartment. They check one more time, they reach in and there's a false like pocket in the back of the glove compartment. There's a second compartment. They reach back there and sure enough, the Rolex watch is sitting there.
So at first you didn't believe her.
I didn't believe her. I almost feel like it was a miracle.
Wow.
So they found it. So there are times where your client's telling you the truth, but the evidence doesn't support it.
So in that particular case, what fascinates me is the way they got caught was they were stupid enough to drive past the police
Right.
department.
Yeah.
And that reminds me of a case, talking about stupid criminals.
You're Free to Go is sponsored by Lang Realty, South Florida's premier residential real estate broker. Whether you're buying, selling, or renting a home or condo, Lang's experienced realtors are standing by ready to help you. Contact one of Lang's top realtors today at 561-703-2427.
All right? When I was a prosecutor, I had this one case, and it was amazing how stupid these people were. So a group of guys decide they're going to rob a warehouse. And they're going to rent a van to rob the warehouse. So what do? They're smart enough, they think, not to use their own identification. So they commit another robbery. They rob a guy in an elevator and steal at gunpoint, steal his identification. They then go and take that license to a Hertz rent-a-car. Now, this is years before, where everything was written applications, before it was all on computers. And they rent the van. They go and they rob the warehouse. But there was a security guard there. And the security guard got in the way, and they shot and killed him. So now they got a robbery in one instance of the individual for the ID. They got the robbery of the warehouse, and then they got a murder. So what happens is somebody on the scene saw the license plate of the van fleeing and gave that number to the police. The police track it down as a Hertz rental. They go to Hertz, and Hertz gives them the information. And, of course, the rental is by the guy who was robbed, but they don't know this guy was robbed yet. They go to the apartment with guns drawn and force the guy to open the door and then put him on the ground, and they're accusing him of being one of the guys robbing the warehouse. And he says, well, wait a second. I was the victim myself. These guys robbed me of my identification. They took my wallet. And at first they didn't believe, but then they found out that he had made a police report. This was the day before. So now they know that they got a false ID. They go back to Hertz, and they look at the rental agreement, and these guys put down the phony name, the phony address, and they also put down a phone number. Guess what? The phone number these idiots put down was their own phone number.
Right.
So the cops call, they make up some story that they're delivering something. Lo and behold, they get the guys.
Right. Yeah. That's probably the only stupid criminal out there, right?
No, hardly. Hardly.
Yeah, so it's like the person who gets arrested 10 times, they confess every time. They continue to confess.
You know, the other thing that I wanted to ask you is, because you do a lot of state court, I've practiced a lot for many years here in Florida in state court. Florida is very unique compared to all the other places in the country. I think there may be one other state that allows us, and it doesn't exist in the federal system. In criminal cases, you get to find out a lot more about what the government has as evidence by being able to take depositions of their witnesses, right?
Yes. So we're able to really dig deeper into the story that our clients tell us. When they read the police report, which we do get, and they see contradictions, we can really dig deep into that in the deposition, which then garners more information that helps our defense typically. In a lot of states, you don't get that. It's trial by ambush. You get in the court and you get
Right.
to
And in
talk.
federal court, you don't get that. In
Right.
fact, in federal court, it's so bad that technically, under the law, you don't even get the statements of the witnesses who are going to testify against your client under the rule, technically, until after that witness has testified on direct examination.
Right.
Now, judges don't enforce that because that would mean they'd have to stop the trial for you to read all that stuff. So now you're ordered to get it in advance, but you don't get it that far in advance. The end result is it is sort of trial by ambush.
Right. Although sometimes the federal prosecutors in particular, they think their case is so strong and that they're in the driver's seat that they will tell you what they
Oh,
have.
I've had
Yeah.
federal prosecutors so confident in their case that they've opened their files. I remember I had a case in federal court in Puerto Rico where I was invited down. It was a great trip. And then I went to this giant room, and they had tables full of documents and everything, and they said, knock yourself out.
Right.
And of course, we know in Florida, we had that crazy case that we met on
Yes.
where there were thousands of files in a lockup, a sheriff's lockup, right?
Yeah.
And we were given the access to look at them because under the rules in Florida, we're allowed to do that. But what was the problem?
Well, they had a very, very serious spider issue.
Right, brown recluse spiders, right?
Deadly, deadly. So I was very careful when we were touching those pages.
We didn't go for many, many months.
No. Well, all right. So we started this episode talking about whether we want to know if the client is whether the client did it or not, and then we start talking about whether they're telling the truth or not, whether they're building confidence with them. One thing I've always found interesting is that, and you reference you do much more federal than I do. I do more state, but as well as federal. But in state, one of the most common crimes there is DUI.
Right.
And what happens with DUI or impairment from drugs or alcohol is it impairs your brain, your thought processes and so forth. So I often find that someone arrested for DUI, they'll talk to me and they'll say, hey, I've got good news. I did really, really well on the field sobriety test. I walked the line perfectly. I touched my nose perfectly. I did great. And then I didn't give the breath test. So they really aren't going to have any evidence other than I weaved once or twice because I dropped my phone, and that's why I left the lane. So we have an explanation. So I'm like, oh, this is good news. So then I get the discovery, which is the legal term for basically evidence, and I get a video of the field sobriety tasks.
And they're
falling down drunk. They are doing their line. They fell down 3 times. I had this one person, it was a female client, and it was a male officer, and the woman started patting the male officer on the head, saying, you look so cute, and then she lifted up her dress and said, do you want some of this?
Oh my
I
God.
said, so, and when I meet with the client afterwards, like, the truth is they weren't lying to me. They just had no recollection whatsoever because they were impaired from the drugs or alcohol they were on, and then their jaw drops, and they're like, oh my God, I don't remember any of that. I guess I better plea.
Well, that's why it's very important, and I've always encouraged prosecutors, show me what you've got. Let me show it to my client. And there's a twofold purpose for that. One is obviously we need to know what we're up against. And the other is if my client sees that it's really, really impossible to defend, then we got to try another route.
That's right.
Instead of going to trial, we try to mitigate. And that's what we often do as criminal defense lawyers, is we realize it's like a parachute. We're not going to be able to give the client a full parachute. We're going to give them a mini parachute. They're not going to die,
Right.
but they're going to break a leg when they fall.
Right.
All right? So the idea is to get them the best way out of this.
And it reminds me so often when a client is interviewing us to hire us, they say, well, what's your winning record? What's your percentage of wins? And it's impossible to answer that because just last week I had someone looking at 30 years in prison, and they wound up resolving the case with a conviction, but 1 year of house arrest.
That's a win.
That's a win.
That's a
right?
win, right?
Yeah. So in this case, he stubbed his toe. He didn't actually break, he didn't die. He didn't go to prison for years. He stubbed his toe as the outcome. It's definitely a win.
Yeah, any lawyer who says they win every trial they have ever tried has never tried a case.
That's so true. Right. They haven't. And sometimes, as they should, a prospective client interviews more than one lawyer.
Absolutely.
And they'll often come to me, I'll maybe the second or third lawyer they interview, and they'll say, well, this guy promised me this outcome. I say, well, he must have a crystal ball, because no lawyer, no matter how competent or experienced, can promise anyone an outcome. There's
absolutely.
Too many variables. There's too many unknowns. We haven't even seen the evidence at that stage.
Absolutely. Jury selection, and we'll do a whole section, a whole episode on jury selection,
Right.
because some of the funniest stories I have are during jury selection, because the stuff that comes out of their mouths when they're sitting there is really quite remarkable.
Right. Yes.
Unfortunately, I don't know about you, but I've never had the opportunity to sit on a jury, because every time I get into that box and they start questioning me and they find out I was a prosecutor and I was a defense attorney, I've tried hundreds of cases, I taught trial lawyering, they don't want to touch me.
That's right. No, that's as far as I've gotten to.
Yeah.
But it is good for us to go through that, because then we know what the the jurors are feeling and experiencing when we're the ones selecting a jury. We know they're tired. We know they're exhausted. We know they're bored. We know their butt is killing them sitting on a hard bench for 6 hours.
Yeah.
So it's good perspective when I do get
But we're
called.
going to get into that
we
later.
will.
We'll get into those crazy stories.
But you asked me at the beginning, does it affect my ability to represent someone when I know they're guilty? What about you?
Well, first of all, I think there's a difference between I believe, I suspect, and I know. The I know comes only when my client is absolutely confessed to me.
Yeah.
All right? And when I believe, it's when I look at the evidence or when they tell me a story that just doesn't sort of add up. But for me, it really, like you, it doesn't matter, as strange as that may sound, because my job is to get them out of this. Yeah. People say, well, isn't that kind of crazy? Because if that's what you're doing and then they committed a crime, aren't you doing something immoral? But you got to look at the bigger picture. The bigger picture is a system. And the system is the prosecution, there's a judge, there's a defense. And the prosecution has to be held to the standard of proving their case. If they've got the evidence, 99 times out of 100, your client's going to be convicted.
Right.
All right?
Yeah.
If their evidence holds up, your client's going to be convicted. I don't care how great a lawyer you are. At the end of the day, all the theatrics, all the civil-tongued devils that are out there are in exchange for the fact that the evidence is compelling when it is compelling, and is going to convince jurors to find your client guilty. So my thinking is very simply, my job is to keep the system honest, because for every guilty defendant I am representing, I'm at the same time defending, by its very nature, the people who are innocent.
Right.
And that's what we believe as defense attorneys.
Right. How about if you don't like your client, though?
Well, that's an interesting thing.
Remember you mentioned the ones that the white collar tend to lie.
Oh.
And after a while, you got to maybe not like them so much.
Absolutely.
Then are you able to defend them as vigorously?
Yes. I'm able to defend them as vigorously. And, you just have to put yourself in a position of separating your personal feeling about the client. And, one of the problems that exists during a trial is when you're trying a case as an attorney, as a defense attorney, and you're sitting there and you're listening to the witness and you're thinking about what objections you're going to raise if the testimony is inappropriate. You're thinking about what questions you're going to ask on cross-examination. You're looking at the jury. You're studying the witness. You're responding to the judge. And at the same time, your client, who's crazed, is yelling in your ear, and you're telling him, shut up, Stop it.
Right.
Write the notes down. Catch me during the break. And I've had clients who not only would do that during the trial, they would be calling me every hour at night.
Right.
Because when you're on trial, you're basically working 18-hour days.
Right. It's your highest priority.
And that's all you're doing. I've done some of my greatest summations in the shower.
Right.
Because the truth is, you're on it 24/7. And then when the client's calling you all night, and I made the mistake once trying a case in Boston where I actually, instead of staying in a hotel or staying by myself, I shared an apartment with my client.
Really?
The good news is he cooked and he did the laundry.
Right.
The bad news is it was 24 hours of the case.
And that was a long case, right?
That was a
Couple
very
months?
long case.
Yeah, I remember that
And
one.
he was a great guy, don't get me wrong, but you need a break. So in answer to your question, a long-winded answer, is it really doesn't matter. I mean, I've had clients that I think the world of. I have clients I really didn't like at all. But at the end of the day, for me, it's doing the job of holding the system honest and fighting like hell for them.
Yeah, and I agree with all of that. I also feel like very honored that someone entrusted their freedom in my hands. And even if I don't like them, I remember that, boy, they made a very serious decision to entrust me to defend them. And also, we're in an area of practice where the cases end relatively quickly, a year or two or three, kind of at the most.
Although we had a case that lasted 5 years,
Yes,
right?
it might be the record, the longest case in criminal history in state court, right? So, but that's the other thing too. You can put up with anything knowing that there's going to be a beginning, middle, and end relatively quickly.
And when it ends, and when one case I remember where I really couldn't stand the client, and he was acquitted, and rightfully so. It was a weak case. We fought it well, and the jury made the right decision. Afterwards, he wanted to have a party, and he invited me, and it was going to be a big thing. And of course, I would have been the guest of honor.
That's right.
And I said, I'm not coming. Enjoy your life. So that's where my commitment to him ended.
Yeah, I get that. You know, today we've talked really about some anecdotal, experiences we've had with believing a client, not believing a client, and so forth. But I know what we really enjoy doing is talking about specific cases, especially
Our crazy cases.
our crazy cases in particular. So maybe in our next episode, we'll get back to that. What do you think?
Absolutely. I've got some crazy ones. I've got one that I know the audience is going to love, in which my client, while he was defending a case, was also working with the government in an undercover capacity to discover jury tampering in that very case. Somebody had come to him and offered to buy the jury, and we told the judge, and he's now working at night with a different set of prosecutors and a different set of agents.
All right, I want to hear all those
And
details.
in the day, they're actually trying the case and trying to put him in jail.
Wow. Okay.
It was insane.
Well, I'm going to personally stay tuned for that one in the next episode because I don't know that case.
Yeah.
So I think what I'll talk about is a client who their whole life since they were a young child always wanted to be a pilot. They always wanted to be a commercial pilot, and they focused on it their whole life. And they took all the classes, they did all the hours, they passed all the exams. They finally got certified. They got their first commercial flight, and on their very first flight, they got a DUI for under an airplane, flying an
Wait a
airplane.
second.
It was
A
very
DUI
for operating an airplane under the
Flying
influence.
while under the influence. Isn't that an
Yes,
FUI?
Yes, it's an FUI.
An FUI.
Yeah. So that's going to be a fun one to talk about.
Well, we're gonna want our audience to listen because we've got some great stories, and we're gonna keep feeding them because we've got, oh God knows how we could fill a
Right.
book, right?
Yes,
with them.
a series
So
of books.
until then, ladies and gentlemen, please stay tuned, and as we've always said, you're free to go.
Down Low Investigations is a sponsor of You're Free to Go. Behind every great criminal defense attorney is a great private investigator. That's why Mark and I use Down Low to investigate cases all over the country. Down Low can help you too, whether you're running a background check on an employee or running a background check on a blind date, or let's say you need someone followed or some other type of investigative work conducted. Down Low is the way to go. Call Download Investigations at 561-843-1010. 1806. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fromson and Mark Nurek and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.